Your offense is aggravated rape. Your original sentence was on July 20th, 1998. You were resentenced on January 20th, 2012. Your sentence originally was life without benefit of probation, parole, excuse me, without probation, parole, or suspension in sentence. You were resentenced in 2012 to life without suspension of sentence. Is that correct?
Yes, sir. I got sentenced to with probation.
Sir, yes will suffice. Is that correct?
Yes.
Okay. Your parole date is June 1st, 2021. You're not eligible for good time, and your full-term sentence is life. Is that correct?
Yes, sir.
Okay, Mr. Smith, your case has been assigned to Mr. Wise. Mr. Wise.
Okay. Back on 4/26 of 19, I see you had a disciplinary, a 21C. Is that correct?
Yes, sir.
You know, the board has a practice within a year, within the last year, you can automatically be denied. But my practice has always been when there's disciplinaries close together like this, and some of these disciplinaries like this right here, it's really hard for me on a very serious crime like you got here to look at it real close. I've looked at your case and went back and forth over your case. But it just kills everything when you're getting write-ups like you're getting right there. Now, is there a reason for that? I know you went through all 4 phases of your sex offender classes, right?
Yes, sir.
This happened after you completed those phases.
Yes, sir.
And I know you family members here, they love you and they care about you and they want to be with you, but I mean, you kind of tie our hands, you know, on some of these things. It's a very serious case here that we're looking at. You've taken some programs. Where are you housed at?
Spruce Street on the East Yard.
Yes. You know, you had a disciplinary issue in 2019, Class B, sex offense, and you was working at Prison Enterprise, is that correct?
Yes, sir.
Did they move you from working there?
Yeah, yes, sir. I got locked. When I got locked up, I spent 3 months in the blocks. I came back. When I came back out of the blocks, I went back on West Yard, and I got my job back. Now I'm back on where I was. Now I'm back on the East Yard.
You know, you got strong law enforcement opposition against your release, and institutional record is poor. You have another sex offense in your jacket there too.
Yes, sir.
I don't have any other questions.
Mr. Marabella.
I don't have any questions, Mr. Chairman. Thank you.
At this time, we'll hear from, well, let's hear from Warren Bernard.
I don't have anything else I could add, Mr. Roche. Mr. Wise went through it.
Thank you, sir. We'll hear from Mr. Randy Meyer of the Jefferson Parish District Attorney's Office.
Good morning, Randy Meyer, Assistant DA in Jefferson Parish, and we're strongly opposed to Mr. Smith's request for parole. Number one, the nature of the offense, he raped an 8-year-old child. There's indications that other children were also sexually molested back then. And he's had 2 disciplinary reports for sex offenses, and in 19, the aggravated sex offense that Mr. Wise was speaking of. The record also indicates a poor institutional record. For all those reasons, we think it's pretty clear that he has not been rehabilitated sufficiently to be released on parole. Thank you.
Thank you, Mr. Meyer. Mr. Smith, well, first of all, we'd like to hear from your sister, Rashawn Rashawn.
Good morning. My name is Sean McKellen. I am Michael Smith's sister. I do want to say thank you for the opportunity for allowing us to speak. So this is an issue, and I have been informed of all of the charges that he has, or the infractions that he has incurred while he's been in prison. My main issue is this offense of the crime happened when he was 16. If you all take a look mentally, he's not capable of understanding some of the things. And I would hope that in prison, even if he's not released today, that there's some type of rehabilitation that you all can ensure that he gets in order to take care of some of these issues. I would hope that he is released so that we can put him in some programs outside of prison, because obviously I don't think the prison system is made for rehabilitation for these type of things with his mental capacity. This happened a long time ago when people on the spectrum were not associated correctly or wasn't given the right treatments and benefits. So even if he isn't released to us, maybe to a treatment program that can help him to be successful and help him to be able to be a productive citizen. There's a lot of issues. I'm a parent, so I have an understanding of what I would feel like if my child was harmed. I've been in the military almost 20 years now, so I'm all about accountability as well. I just think that, I've talked to Mikey, as we call him, and he's remorseful, but I do think that there should be some type of programs that he can glean from so that he can be rehabilitated. With the crimes that with the infractions that he's received in prison, obviously there's a problem that's not being handled. And I think it's because the rehabilitative systems in Angola is not great for him and his mental capacity. If you listen to him speak, you'll understand that he's not able to get across what he should be able to at his age. This happened when he was 16, even though he was charged at 18 or convicted at 18. The crime happened when he was 16. And in my opinion, he wasn't even at a 16-year-old mental capacity. So just take all of this into consideration when you all make your decisions. Of course, any conditions that you all deem necessary, we're good with, but I would hope that he would be able to be released to a different type of facility so that he can get the help that he needs. Thank you for your time.
Thank you, Ms. McKellen. Mr. Smith, would you like to make a brief final statement?
Yes, sir. I'd like to thank y'all for allowing me for this time. And I do have a statement that will probably help me out, but I hope y'all take into consideration that it's been a while since my last write-up, a year and something. Even though it's been a while, I'm not. I am remorseful for what I did, and I'm sorry for hurting the victim, his family, and my family in the process. And this is a long process for me to go through, and I appreciate y'all time. Thank y'all.
Thank you, Mrs. Smith. Is the panel ready to vote?
Yes, sir.
Mr. Wise?
At this time, I'm gonna vote to deny. I'm voting deny because of a disciplinary write-up of 21C in 2019. Also, very strong law enforcement opposition and DA opposition. And I am saying this, you get in some programs, you work in some programs, if there's any way, Warden, they can, and I know they're doing some kind of mental health treatment there with you and help you any way they can. Thank you.
Thank you, Mr. Wise. Mr. Marabella.
Mr. Smith, I'm going to agree with Mr. Wise this morning. I'm going to deny your parole. I'm going to suggest that you take whatever classes you can. I think your sister made a good point on maybe you getting some mental health help and some things like that. So I would encourage you to try to do as much of those programs as you possibly can. So good luck to you, sir.
Thank you.
Mr. Smith, I think all the services that you need is located at Louisiana State Penitentiary. All you have to do is avail yourself to those services. When you put into those, excuse me, when you put into those classes, sit on the first row, pay attention, get all the information. All the services that you do need is at Louisiana State Penitentiary. Mr. Smith, you received 2 votes to deny your request based upon a general disciplinary conduct that's unacceptable, law enforcement opposition, a poor institutional record, and strong opposition from the Jefferson Parish District Attorney's Office. My vote also is to deny your request. You have received 3 votes to deny your request. Your request for early release has been denied. You have a good day.
All right.
Okay, I'm going to share with you the details of the case and in the court appeal where they did bring up his IQ. And we could then chat about that. So he was convicted by a unanimous jury of aggravated sexual assault of an 8-year-old boy and sentenced to life imprisonment without the benefit of parole, which is quite incredible that they give a life sentence for this in 1999 when it was decided. But I mean, we just don't see that. I mean, we see this type of stuff all the time where they get just 5, 10, 15 year sentences. So I mean, you know, it's just it always confuses me. Now, they want to say, one, was the evidence the evidence was insufficient with basically that it actually happened without his confession, and 2, the sentence is unconstitutionally excessive. So the victim in this case is called G.A. Herein testified that on June 16, 1996, he was watching television and about to fall asleep when Smith put his hand over his mouth, pulled down his pants, and tried to stick his weenie in my butt. That's his quote. That's what this poor 8-year-old kid experienced. So, yeah. G.A. said Smith was squishing him and had his thing in his booty for about 1 minute when his cousin walked into the room. Smith then fled. Janita testified that she was babysitting for G.A. that night and that she walked into G.A.'s room and saw Smith jump off the victim, fasten his pants, and leave. Janita said that both Smith and G.A.'s pants were partially pulled down. Deputy took a statement from the victim and a voluntary statement from Smith. Deputy Yorsh told the jury that Smith's confession that he grabbed G.A., took my pants off, and started to put I grabbed him, took my pants off, and started to put in his booty. I put my penis in his booty, and his sister walked and jumped in. they're saying to be considered full-on sexual assault in this case, there must have been proof beyond reasonable doubt of some, full penetration. GA's testimony, along with Smith's confession, was sufficient to support this conviction, although we note the testimony of the victim alone, unsupported by physical evidence, can also be proof. Okay. And there's no doubt here that the jury believed in the 8-year-old. So the 8-year-old, they put the 8-year-old on the stand. So Smith was 16 years of age when he assaulted GA. 2 doctors testified in Smith's trials. Dr. Reen, a psychiatrist, and another clinical psychologist. Dr. Colville said Smith had borderline mental disabilities in what Culver called that gray zone. Smith's intelligence is below average, Dr. Culver said, but he is not in any obvious sense very mentally, I'll just say it, YouTube algorithm, if you want to strike me down, whatever, retarded. I'm saying this clinically, reading it. Dr. Culver was asked if Smith knew right from wrong when his crime was committed. Dr. Culver said, as best as I could determine, he did know right from wrong when it occurred. And that's obvious. He jumped up and ran away. He covered his mouth so he wouldn't scream. Dr. Sauter testified that Smith's IQ was 67, but that Smith, did not consider Smith to be mentally retarded. Smith was, according to Dr. Sauter, right on the edge between that and just being in a very, very dull, low average range. Smith, Dr. Sauter found, is quite capable of knowing the difference between right and wrong. Now, the thing is about whenever doctors testify as witnesses, I take very little credence to what they say, because if the state brings the doctor, you pretty much know what the doctor's going to say. And when the defense brings a doctor, you pretty much know what they're going to say. And they can both have completely different opinions. It's who's paying them. So, I'm just saying that in general, I mean, you can clearly look at him and he looks exactly what they described, but I'm also maybe even, who knows? He's obviously not, he obviously has a low IQ. Smith argues that the life sentence is nothing more than a needless imposition of pain and suffering for a youthful, mentally challenged offender. Smith received the only statutorily mandated sentence for one convicted of, this is interesting. That was the mandatory sentence at the time? And they're saying the trial judge should have deviated from it. What we've seen, I guess they just say the legislation changed. They said, you know what, life for that, it's too intense. We should just make it 10 years. I obviously have to do more homework on legislation and when it all changed from mandatory life to basically whatever the judge wants. And they're basically saying that the judge had the ability to not give the maximum sentence. Constitutes crime punishment shall be meted out by the court. Therefore, fixing penalties is purely a legislative function, but the trial judge has the discretion to determine the appropriate sentence in the sentencing range fixed by the legislator. His attorney objected the sentence but didn't give a reason. That's great attorney, huh? And it doesn't even seem that his attorney brought their own expert witnesses. It was just the state that brought their expert witnesses. Now, and of course it was denied. Now the question I guess we can bring to you is, should he be in a mental hospital or Angola? I don't think he should ever be free because is a danger, and you can't take a coin flip and put another child's life at risk. Also, if you're curious about the full details of the write-up that he got, and again, thank you, Jen, for emailing me a copy of Angola's handbook, a 21C. So it's a sex offense, and C means that it was an offender on offender contact or attempted contact between, their private parts and other private parts, including penetration or attempted penetration, however slight contact or attempted contact between the mouth. And they just go into all those words. What I'm trying to find out is if implement or animals. 2 or more offenders who have obviously been interrupted immediately before or after carnal copulation, use of genital organs for one of the offenders. Okay, so it's not like he was doing it against someone's will. It seems that this was consensual. Oh, well, actually, it says non-consensual and or consensual involving offender on offender or staff person strictly prohibited. Oh no. So a class A would have been non-consensual. C means it was consensual. But there you have it. You tell me where you think. In my opinion, he should not be free. You can't. He is a danger. The child you cannot risk. What is his freedom to flip a coin on changing another child's life forever? I guess the question is, you can say, is should he be in a different facility? I don't know the answer. You tell me. That's my opinion. With that, I'll let you go.